Hello, everyone, and welcome to Uncivil Law. And I am going to give all the Vic Mignogna fans out there who have been endlessly criticizing me a chance to prove me wrong right out the bat, because I'm about to directly contradict Ty Beard on page 1. So one of us is wrong, me or Ty. So we're going to give you a chance to prove me wrong and prove Ty right and prove that he is really the true master of this case, because he has filed something he is calling a Sur Reply. It's right on the first page. It says it right there. Vic Mignogna's Sur Reply to Anna Pelle's Funimation's response. Okay, no. You can't do that, Ty. You can't file a Sur Reply. That's not possible. Okay, so either I don't understand something, or and Ty is a master, or I do understand something and Ty is an idiot who doesn't know something. So one of us is massively wrong. Here's my claim. Vic cannot file a Sur Reply. That's my claim. Here's why. All right. First of all, you need to know what a Sur Reply is. All right. So I'm going to tell you what a Sur Reply. There are two reasons he can't file a Sur Reply. One, because he doesn't have permission, and one, because it's impossible. All right, so you need to know what a Sur Reply is. All right, so normally when you have filings like this, you have the initial filing, and then you have the response, and then you have the reply. So the plaintiff or appellant, as the case might be, whoever going first files the initial petition, the initial whatever, right? So the appellant files the initial brief, the initial pleading. Then the appellee or the defendant or whoever is second files the response. And then the plaintiff or appellant gets to file the reply. So it's initial, response, reply. If the defendant wants to go again, if they want to file again, that's when you get into a Sur Reply. So a Sur Reply is the fourth thing in a sequence. It's the initial thing, the response, the reply, and the Sur Reply. All right? And they alternate between sides. Side 1, initial thing. Side 2, response. Side 3, reply. Or side 1 back, reply. Side 2, Sur Reply. You see what I mean? They're going back in sequence, going back between them. Okay. So there are two big problems with this. There are two big problems with this right off the first page. Number one, I looked at the Texas Rules of Appellate Procedure. The Texas Rules of Appellate Procedure don't mention the word Sir once at all. The Texas Rules of Appellate Procedure do not allow for a Sur Reply. The word Sir does not appear in the Texas Rules of Appellate Procedure anywhere. And I did some Googling in advance of this stream to double check. And I found people who had attempted to file Sur Replies, and as part of it said, there is no rule for this. So I'm making a motion. Would you please allow me to do this? They file a motion so they can file a Sur Reply because they say there is no rule that allows me to do this. So number one, he can't do this because he hasn't filed a motion. You can't file a Sur Reply unless you ask, because there's no rule that allows for it. You have to ask permission. So that's one, he doesn't have permission. And even more fatally, too, he's the wrong party. Only Funimation can file a Sur Reply. Vic can file a reply. Vic can't file a Sur Reply because he's on the wrong side of the V mark. Only Funimation could file a Sur Reply. So Vic Mignogna has filed a Sur Reply, even though one, the rules don't allow for it, and two, he's the wrong party to be doing it. So either I massively misunderstand something, or Ty Beard is an idiot. So all the Vic people out there who have been saying you don't understand the first thing about Texas law, this would be the time to feel free to at me. Let me know why I massively misunderstand what a Sur Reply is. Let me know what I massively misunderstand. Who can file it? Please point out how the Texas Rules of Procedure mention the word Sir at all in any context and allow for it. Please show me a motion, and please show him he has the right party. This is your chance. This is your chance, Vic people, to show how I've been wrong all this time. I'll be waiting. But in the meantime, we are here with what we are going to be calling the Sur Reply, because that's totally a thing that Vic can file somehow. Okay, so we are going to be reading this Sur Reply because that's a thing that Ty thinks that Vic can do somehow. Okay, great. So we're here with the Sur Reply by Vic Mignogna, which is something that we apparently can do. And okay, great. And so we're in the table of contents and some holdings and stuff, and we've got some issues presented. We all know what the issues are. Great. All right. So let's go right to the statement of facts. Now that we've gotten past stage one, now that we've gotten past page one, and a massive legal mistake because we've called it a Sur Reply, which we can't do because we're the wrong party and there's no rule that allows for it, and we haven't filed a motion and nothing makes sense. Now that we've gotten past page one, let's go to the statement of facts and read those. Okay. Vic Mignogna maintains and refers to this court to his statement of facts in the appellant's brief. Vic provides this reply to bring, he calls it a reply here, provides this reply to bring this court's attention to appellee Funimation's unsupported or unfairly distorted factual allegations and to highlight the importance of certain critical facts. Good. Tell us some facts, Vic. That'll be helpful. Maybe you're better on the facts than you are on the law. One can only hope. While Vic is a career voice actor, Funimation's statement about Vic's prominence is exaggerated. Ooh. Vic provides voice acting for English dubs of Japanese animated cartoons or anime. Yes. Fans of the genre, the anime community often attend conventions. Yes. The members of the anime community post news and information they find on relevant websites. I'm sure they do. But nothing in the record establishes that Vic has any prominence whatsoever in the general public that would justify treating him as a public figure. If we were talking about general purpose public figure, you would be right. General purpose public figure is pretty hard. Here's your quick and dirty test for public figure. Have you ever been mentioned in the National Enquirer? Preferably on the front page. If you've never been in the National Enquirer, you're probably not a general purpose public figure. So as far as legal tests go, it's not exactly dispositive, but it's pretty close. If you've ever been in the National Enquirer, if the answer is no, you're probably not a general purpose public figure. If the answer is yes, you might be, but that's probably a necessary step, yeah. Put another way, there's no evidence in the record that establishes Vic's prominence outside the anime community. Okay, I believe you. You are correct. More importantly, nothing in the record shows the resolution of the parties' disputes would have any significant impact on members of the anime community or the general public. I'm not sure that really matters for public figure status one way or another. Whether or not it would have impact on the public at large doesn't really go to whether or not someone's a public figure. Like, George Clooney is probably a public figure. Let's just take a general purpose public figure. Let's just take it as a given that George Clooney is probably a general purpose public figure. So if George Clooney was in some dispute with someone somewhere, he's a general purpose public figure. Whether or not how that case comes out may have zero impact on the public at large. Does that mean he's not a public figure? It does not. That whether or not it impacts the public at large in any way is irrelevant. You know, George Clooney in massive dispute over a contract of whatever. Does that impact the public in any way? Not really. Is that the task for a public figure? It is not. So sure, it won't impact the public at large. Does that matter? No, it does not. That's great. Despite Funimation's characterization to the contrary, Vic's tweet is not properly considered an apology or an admission of any kind of any sexual assault, harassment, or misconduct. There's a footnote, which cites the court record, which I'm not going to bother reading. In the January 20th, 2019 tweet, Vic specifically denies several allegations against him. Any allegations of sexual harassment, sexual assault, or most disturbingly, kitty stuff are completely and utterly false. My heart weeps for anyone who endures the violation of this kind. So to be accused of harming others in this way, I have no words. I also like how there's triple dots. Was there triple dots in the original, or are we leaving out words? Normally 3 dots is an ellipsis that implies we're leaving out words. Did we leave out some of the words of the tweet? If we did, then we're doing a bad thing. We're using it as critical evidence and we're putting in some ellipsis. So are the ellipsis in the original? And there's no sick. So just a practice tip here, by the way. All right, here's a practice tip. If you're going to quote something verbatim that needs to be clear that's verbatim, what you normally do is you put brackets and you write SIC, sick. That means, yes, I'm repeating this as it was written originally, so that you don't mistake what I'm doing as a mistake on my part. So if I want to quote someone who wrote something incorrectly or had bad grammar, or perhaps most notably in this situation, if the ellipsis were in the original, I, as a lawyer, would absolutely be putting SIC in brackets after those ellipses, because I want the court to know that those are part of the original. I'm quoting the ellipsis, but I didn't do that. I didn't write SIC. So it makes it look like I am putting in the ellipsis myself, and I'm leaving out part of the critical tweet. So one way or another, this is bad lawyering on Ty's part. This is bad lawyering. Because one of two things is true. Either Ty left out part of the critical tweet, which seems disingenuous, or he failed to put brackets SIC after the ellipsis to make sure it was clear that those were in the original. So either way, it makes it look like that he's hiding the ball. Way to go, Ty. That's a nice one there. Good job. Yeah. So way to go on leaving out the SIC mark and or trimming the tweet down. The only apology was for an unrelated comment made years ago. Sure. Funimation's tweet specifically reference the Mignogna situation on Twitter, where the only fair reading and understanding of the Mignogna situation is the assault allegations against Vic. Fair? Yeah, I think they were about him. I think that they were able to get that far. There were other problems with it. We've covered that in the many, many other live streams. But yes, I think they were about and concerning him. I got that far. Vic's assertion that the tweets were truthful puts the cart before the horse. Vic vehemently denies the allegations on Twitter, which is all that is necessary to defeat a TCPA motion. Okay. In my humble opinion, this is bad lawyering. There is being a good advocate for your client and trying to couch things in a way that is favorable to your client, and then there's just being disingenuous. And to me, as an outside observer to this thing, because I don't have a dog in this fight, I don't benefit either way if either side wins. I am a neutral third party, and, for whatever it's worth, I'm very skeptical of the Me Too movement in general. So my biases would tend to suggest that I'd be in favor of Vic. But I'm not, because it's just not legally there. And, my biases aren't going to cover you that far. So I really do not like this, because what he's writing is, the denial is enough to defeat a TCPA. No, it's really, really, really not. Really, really not enough to defeat a TCPA motion. And you should know better. And in fact, you probably do know better. And being as charitable to you, Ty, as I can possibly be, I'm going to assume that you wrote this on the hope that, the court would read this and kind of look past the issue. But unfortunately, at this point, I don't think that's happening. I think this is just bad lawyering. I think this is putting yourself and your client in a bad position. Because way, way more is needed to defeat a TCPA than just, I disagree with you factually. It is a necessary but not sufficient condition to defeat a TCPA motion. Yes, we disagree about the truth of it is necessary but not sufficient. And what you wrote is it's sufficient, and it's not. And the court knows it's not, and you seem to be arguing something that's not the law. And the court has lost any interest in anything that you have to say at this point. So, no, that's bad lawyering. Yeah. Vic vehemently denies the allegation, which is all that necessary. It is not all that's necessary. It is necessary, but it is not sufficient. If it were all that was necessary, yes, that would be another word of saying sufficient. But it is not sufficient. It is necessary, but not all that is necessary. Oof. We're on page 3, guys. It's not going great. It's not going great with the I Stand With Vic crew over here on Uncivil Law land. It's not going great with the I Stick With Vic people. I continue to apologize to the I Stand With Vic people because I think that you guys misunderstand me. You seem to think that I want this to occur. I don't want it to occur. I'm trying to give you my best opinion as to what I think will occur. I'm trying to give you my best opinion as to what the law is. I'm trying to give you my best opinion as to what I think the outcomes are likely to be. A lot of you guys seem to think that, like, I have it out for Vic, or I want him to lose, or I think that Funimation should win, or blah, 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 whatever. I don't have a dog in this fight. It doesn't benefit me either way. The only thing that has any possible benefit to me is if I am ultimately shown to be right, because then it will help me seem like a smart guy, which is nice. So the only incentives I really have is to try to predict the legally correct result. Because then if I am legally correct, then people say, oh, well, he's a smart lawyer and I trust him more. And if I'm not, then people say, oh, he's an idiot and people will trust me less. So really my only incentives are to try to predict the correct result as terms of what the legal result will be, in terms of its outcome. Correct as in this is what will occur, not correct as in moral. So, not saying that this is morally good or morally bad. I'm trying to tell you this is legally where I think things are. And legally, I think Vic is somewhere up a creek without a paddle right about now. So, not saying it's good. Yeah. The only fair reading and understanding of the Funimation tweets is that Funimation concluded the allegations he had committed sexual harassment and sexual assault were credible and were the basis of terminating his employment and excluding him. The record is clear by Funimation's meeting of investigation. Well, I will agree with you there. I think that is a very fair reading of the tweets. Now, that is part of the problem because, Funimation may be in a privileged position to write those things and say those things. So yeah, I think there's a fair characterization of the tweets. And in terms of the record shows what Funimation means by investigation, I mean, it didn't strike me as particularly slipshod. I mean, it wasn't the most thorough thing in the history of time, but they actually did do some interviews and they actually did some reviews and HR got involved. And, there's a fair amount here. So was it a perfect HR investigation by Funimation? No. But I've definitely seen worse. I've definitely seen worse. So, yeah, maybe it wasn't the greatest thing of the history of time, but it was legally sufficient, to use precisely the right word in this sentence. So, it didn't strike me as particularly derelict, negligent, slipshod, half-baked. It seemed reasonable. More would probably be nice, but it was enough. And, if I were Funimation's lawyer, I'd probably be saying right about now, maybe next time we could take a couple extra steps. That would be nice to help protect us in the future. But I'm not having a major heart attack over this if I'm Funimation's lawyers. Vic's February 13th, 2019 tweet is not an admission as to the accusation. His tweet is a simple statement of appreciation, stating, until the last few weeks, I had no idea that any animosity ever existed. Okay. Which I don't remember reading that from the tweet from before. So is this a different tweet, or is that the part we took out, or what are we doing now? Summary of argument. All right, let's get into the legal aspects of this. Funimation assumes without evidence he's a public figure. He's been held to be a limited purpose public figure, which he is. He's notable in the community. He goes to conventions year after year after year. People come to him. They come to his panels to listen to him speak. They get autographs signed by him and photos taken with him. People want to see him. He is a notable person in this world. He's a limited purpose public figure. It's not super hard to reach that conclusion. The only evidence offered in the trial court to support Funimation's argument Vic is a public figure is that, one, Vic provided voice acting work on the production of Dragon Ball Broly. The Vic has an IMDb career detailing his career from 1972 to present, which is kind of suggestive. the number of Vic's Twitter followers, website articles regarding the tweets, and an affidavit from the director of public relations claiming the existence of certain hashtags on Twitter. I feel like they had a little bit more than that. And also, there was evidence from your side, which the court can consider. So, just saying. The evidence does rise, this evidence does rise to the level necessary. Wow. Okay, that's great. That's great. All right, well, we're done here. We're done here, guys. We are legally done here. We are done because Vic has conceded the central point. Vic has conceded the central point. Let me quote this verbatim from Ty's lawyer. All right, let me quote this verbatim. This evidence does rise to the level necessary to establish Vic as a general purpose public figure. Well, that was easy. That was easy. Well, thanks for tuning into the Uncivil Law Hour. I've been your host, Uncivil Law. As Ty Beard confesses that, yes, Vic Mignogna is in fact a general purpose public figure. The evidence does rise to that level. We've seen it in black and white on the page in this Sur Reply that, yes, Vic Mignogna is in fact a public figure. I had my doubts, personally, that he was a public figure. But, you know, if Vic Mignogna himself, through his lawyer, wants to say, yes, this evidence does rise to the level that he's a general purpose public figure, well, who am I to disagree? Yes, okay, great. Vic Mignogna is a general purpose public figure. That we're done here. End of analysis. I hope you enjoyed this channel. If you like it, please give me a like. Yeah. This evidence does rise to the level necessary to establish Vic as a general purpose public figure. That's great. Maybe perhaps we forgot a word, like the word not. Way to go on the editing there, guys. First of all, you called it a Sur Reply, and second of all, you made a mistake in the central point of your argument. We're doing great. All right. So having confessed that we're a general purpose public figure, let's press on anyway. The existence of discussion of a particular topic on the internet cannot by itself make someone a public figure. No, probably not, but you know what can? Us confessing to it. Funimation failed to provide the trial court with any evidence that the resolution of this dispute would impact any person's decision to attend a convention or view a particular production, which incidentally is irrelevant to anything. That doesn't matter. Funimation failed to produce any evidence that it would affect a person's buying decision or a person's ability to attend a convention. What does that have to do with general figure? What does that have to do with public figure status? Absolutely zero. It has zero to do with any of these things. Okay, yeah, we failed to provide any evidence that it would make someone more likely or not to attend a convention or thing. Does that have anything to do with public figure status? No. Wow. This court should reverse the trial court's dismissal of Vic's claims against Funimation because the trial court was presented clear and specific evidence supporting each and every element of the claim as required of the claim supported by the Texas Citizens Protection Act. Only if the Second Amendment is part of the record, and no. Specifically, Funimation's own motion to dismiss offered testimony and evidence by and from Vic denying Funimation's allegations. Yeah, Funimation offered Vic tweet claim. Yeah, tactical. Did you see the part where Vic's lawyer admitted to the central part? How long have you been here, Tactical? Have you been here for a little bit? Oh, Tactical missed it. We have to go back for Tactical Bra because we like Tactical Bra. Yeah, Tactical. The case is over because Vic's lawyer has conceded the central point of the argument. So we'll just go back up for we'll go back up to. That for yeah, we'll just go back up to that for Tactical's benefit, and we'll I want to remind everyone. This is Vic Mignogna speaking because it's his lawyer speaking. So Vic himself is writing this, as it were. All right, And what Vic has said is, quote, this evidence does rise to the level necessary to establish Vic as a general purpose public figure. So Vic is a general purpose public figure because Vic himself says so. Way to go, Vic. That's genius. Good work. Well done. Yeah. So, yeah, that was good. Also, we've called it a Sur Reply, even though that's not a thing that we can do. But we're looking past all these minor issues, these minor niggling issues. Funimation attempts to argue that truths are tweetful. It should succeed on the TCPA, when in fact a proper analysis is not whether the tweets are truthful, which is a question of fact, well, that's part of it, but whether Vec provides sufficient rebuttal evidence, namely his denial of truthfulness. We may need more. Yeah. The short answer to that question is yes. Vic provides sufficient evidence to dispute the truth and thus defeat the TCPA motion. That's not really what is needed in the TCPA motion. We've covered it a little bit. We need a little bit more than just, oh, it's not true. Funimation argues his tweets cannot be reasonably construed as allegations of sexual assault. Again, Funimation's own evidence is fatal to his argument. I think we're there on that part of it. Yeah, I think we can get past that element, but it doesn't matter. Specifically, Funimation's Vice President of Operation, Karen Mika. Her name is Karen. Excellent. So we have Vice President of Operations Karen over here. Stated in her affidavit that Vic was terminated based on the results of an investigation prompted by social media posts on Twitter. These tweets prompted Funimation's investigation where an accusation made by Hanlia. Is that a person's name? I can only assume that Hanlia is a person's name because it's not English and it's not capitalized. So we're an accusation made by something that's not in capital, so it's not a proper name because it's not capitalized, and it's also not a full. Who's Hanella? Do we want to give a last name to this person? Do we want to put it in capitals? Who's this? It's an accusation made by, I don't know, the Mongols maybe, against Ilyich Gorodola, and accusations of sexual harassment levied against Vic by the appellees. $5 from Q Squared. Thank you for the super chat. Please, please, please read more things like this. I love it. You're practically clapping up. Makes the whole live chat experience a ton of fun. Man, I'd love to read more things like this, but most lawyers are not this bad. Normally, to get this level of comedy, I have to read a pro se. Yeah. Funimation's tweets can only be read as responses to various tweets accusing Vic of sexual misconduct and demanding action by Funimation. Indeed, as noted above, Funimation of Operations Karen confirms the investigation was prompted by a social media post. Yeah. I love how we just dropped it in like a name, and we don't want to Funimation not only terminated Vic, but it also tweeted to thousands of followers following an update on the Vic Mignogna situation. Funimation's tweet said Funimation would not be engaging Vic in future production. This tweet alone can rationally be inferred as an accusation of misconduct. I'm with you. We can get that far. Yes, I think that they can be read in sequence as a implication against Vic. I think the two statements can be read as contemporaneous accusations. Unfortunately, it doesn't matter, but yes, you have that point. For whatever it's worth, congratulations, not that it matters. Funimation, however, confirms the relevance of the misconduct allegations with a second tweet saying it does not condone harassment. Yeah, I'm with you on that. One. Funimation's tweets were entirely gratuitous and unnecessary. Well, they might have been unnecessary, but I wouldn't go so far as to say they're gratuitous. They did come with an investigation, which is probably enough to meet the minimum standards for me as the lawyer not to completely freak out. Probably should have been a little bit more, but it meets the minimum. And it was made in good faith with enough evidence. So was it gratuitous? Maybe a little. Was it unnecessary? I don't know. But is that matter? Not really, because freedom of speech, when you say things, you don't have to speak things that are necessary or non-gratuitous. You can say things that are both unnecessary and gratuitous. It's part of the wonderful aspects of the First Amendment. You can say gratuitous and unnecessary things. The First Amendment is nice. It is a nice to have. As Vic's causes of action for tortious interference with existing and prospective relationships, the trial court is presented with sufficient evidence. Well, not in your second amended. Well, not until your second amendment, which was filed late and is the whole basis for this. And you're just treating it like it's there. No. I mean, your only hope in this world is that second amended being the thing. And the Court of Appeals, I don't see that happening right now. I don't see that happening. I know there's some really interesting, the funny thing about it is the I stand with Vic people, the community at large, are better lawyers than Ty is. Because a lot of you guys in the community at large have made much better legal arguments than Ty has. A lot of you guys probably should have come together and written the brief. You would have done better. Because a lot of the things you said made a lot of sense. Like, here were a whole bunch of things, and here was a whole bunch of things, and you could have gotten the statements together, and a whole bunch of stuff. You could have done it better. But unfortunately, none of these arguments have been presented well. The ball has been dropped at every possible avenue. The way this is presented is a disaster show. None of the arguments have been well preserved or well presented. So, in some hypothetical world where the I stand with Vic people were collectively Vic's lawyer, you guys might have had a better shot. Unfortunately, what you did have was Ty Beard, and it didn't go that well. Yeah. It's not going well. And I feel like I'm in a position to say I feel like I'm in a position to have an opinion about Ty at this point, since he labeled his thing as Sur Reply and has also conceded that his client is a public figure. I feel like at this point I'm able to say, maybe Ty Lawyer is not the greatest lawyer of all time. Maybe those were some problems. In my opinion. Which, if Ty Beard wants to sue me over, I am in Texas now, so, if he wants to find out more about the Texas Citizens Protection Act or Participation Act or whatever the P stands. You see, I don't actually even need to know what the P stands for in this sentence to know I'm protected by it. So, feel free, I guess. We can go to court some more. That'll be fun. Maybe I'll get the I stand with Vic people to be my lawyer, because they obviously know how to write a law brief, because a lawyer shouldn't represent himself. So I'm seeking legal counsel for a future lawsuit of Ty Beard against me. So if the I stand with Vic community at large wishes to represent me, let me know, because you guys obviously know what you're doing. As the Vic's cause of action for tortious interference, the trial court was presented with sufficient evidence. Yeah. The trial court found improperly that Vic is a public figure. They said limited purpose. And also you conceded to that point, so whatever. The trial court's error in finding Vic was a public figure led to erroneously requiring Vic to prove... led to erroneously require Vic. I was trying to determine if that's good grammar or not. I'll give you a pass. Erroneously require Vic to prove actual malice in connection with the defamation. If a plaintiff in the defamation action is a public figure, the plaintiff must show defamation acts with actual malice regarding the truth. If plaintiff is a private figure, he needs to only show they were negligent. Yeah. For the purposes of defamation liability, there are two classes of public figures. General purpose public figures, which apparently is my client. Good. And limited purpose, who are persons who thrust themselves into the forefront of particular public controversies in order to influence the resolution of those issues, who voluntarily inject themselves or are drawn into a controversy, assuming special prominence in the resolution of public questions, and thrust themselves into the vortex of an issue, or engage the public's attention and attempt to influence outcome. Query whether or not I'm a limited purpose public figure or not, but, we can have that debate. That's fun. Funimation supports its claim that Vic is a public figure by asserting that Vic provided voice acting work on the production of Dragon Ball Broly, that Vic has an IMDb career, that he has a number of followers, website articles, an affidavit, and he had a fan club called the Risen Bull Rangers. Funimation's evidence is in support to finding. Well, the trial court also took notice of the fact that the hearing was well attended, which is something they can take note of. It is happening right before their eyes. This hearing seems to be very well attended. Maybe he's a limited purpose public figure. And also there's evidence presented from your side, and also you've confessed. So between all those things, I think we're there. General purpose public figures have assumed a role so prominent in the affairs of society they become celebrities. Absent clear evidence of general flame or notoriety and pervasive involvement, one should not be characterized as a general purpose public figure. It's not what you said earlier. Funimation presents no evidence that Vic possesses general fame or pervasive involvement in the affairs of society. We're probably all better off as a result. Instead, Funimation points to website articles that include threads between Rial and her fans on Twitter. Funimation's articles go to show that Rial was using her false accusations in an effort to gain attention. The same is true of Marchi. Statements do not establish that Vic is a public figure. Furthermore, Funimation provides no explanation as to how Vic's voice acting worked, holds such significance among movie fans that resolution of the accusations will have any impact on the general public. That's not the right standard. You keep saying this. You keep coming back to this. This is like the third or fourth time you've mentioned this. That it has an impact on the general public. That's not the right standard. That has nothing to do with anything. Why do you keep mentioning this? It doesn't matter whether it has impact on the public or not. That's not what general purpose public figure means. It means that you are of note to the public. The public knows who you are. You are a person of public prominence. Whether or not anything you do has any impact on the public at large is irrelevant. I don't know why. This is like the third or fourth time you've mentioned it. It just doesn't matter. Yeah, they failed to show that it has any impact on the public. It doesn't matter. All it matters is if the public at large, or a subset thereof, has a fascination with you, sufficient to grant you this status. So it's like the third or fourth time you mentioned it. It's just legally irrelevant. I look forward to the I Stand With Vic people telling me how it's super, super legally relevant and the most legally relevant thing of all time. I look forward to that discussion. That'll be good. I also look forward to them telling me how a Sur Reply can be filed by Vic. While Dragon Ball Broly was successful for an anime movie in America, the trial court incorrectly concluded that he was elevated to the status of public figure by participating. Not really sure that's exactly what the trial court said. While Vic provided voice acting, the film is an anime movie with limited audiences. It does not follow that him working on it establishes him a public figure. Yeah, that one piece of evidence by itself probably does not establish it, yes. That's probably not enough to grant even limited purpose public status. Yeah, the fact that he worked on this one movie, even a notable movie, I mean, it's Dragon Ball, which is pretty big for anime. So, but even the fact that he provided a voice for one character, that's probably not enough. You know what probably is enough? When he went to conventions year in and year out and appeared on panels and had people line up to meet with him and take photographs with him and sign autographs for year upon year upon year upon year, and people come to see him. Yeah, that was probably enough. There is no evidence that the group of individuals who participate in internet discussions about accusations is so large it constitutes the general purpose. Thus, he's not a public figure for all purposes or all contexts. But I thought you said he was. I'm so confused. There's insufficient evidence to support a finding that Vic is a limited purpose public figure. Okay, sell me. Sell me that he's not limited purpose. To determine whether a person is limited purpose, Texas courts apply 3 parts. The controversy issue must be public, both in the sense that people are discussing it, and in the sense that people other than the immediate participants in the controversy are likely to feel the impact of its resolution. Ooh, no. Ooh, and I see what you're doing, too. And this is a no-no. No, and I see exactly what you're doing. So you're trying to conflate 2 different kinds of limited purposes. So there's limited purpose public figure in a more general sense, and there's also like issue specific. So maybe, for example, the Covington Catholic kid. Now, he may not be limited purpose, and personally, I don't think he is because he didn't really inject himself. Although the Indian American guy, Nathan Phillips, he's a better example. So Nathan Phillips, because he acted, right? That was his guy's name, right? In Covington Catholic, the Indian's name was Nathan Phillips, if I got that right. Hopefully my memory is good enough. But anyways, he's taking steps to affirmatively inject himself into a specific incident. So, like, you're trying to conflate 2 things. That he's a, in general, limited purpose public figure. Like, he is within his domain. Or there is a special domain. And you're trying to use the special domain definition of limited purpose. You're trying to say, well, he's not a generally speaking limited purpose. He's limited purpose or not because of this particular issue. So you're trying to show limited purpose status based on the issue specific purpose. So he's not limited purpose except for this issue. And this doesn't qualify as an issue specific limited because it doesn't have an impact on the general public. So now I see what you're doing. And now I see why you're doing it. You're bad lawyering because that's not really the issue. So you're still bad lawyering, but now I see why you're doing it. You're trying to use this other definition of limited purpose. You're trying to use this idea like he's not in some generalized sense. I have no better word than general, which is like, I need a better word because then because there's general purpose and limited purpose. And I'm talking about a generalized limited. I need another word other than general. He's not a broad, how about broadly? He's not a broadly speaking limited public purpose, but he is in this issue. He is or is not in this limited issue. And because he's not in this limited issue, because it doesn't impact the public, therefore he's not limited purpose. So you're trying to use this alternate definition of limited purpose. So I finally figured out why you're doing it. No, that's not what the court said. They held him to be a broadly limited purpose public figure. Because again, I'm running out of adjectives here. Hopefully you guys are following me enough, right? We've got general, and general limited. I'm running out of vocab words, but you should understand hopefully what I'm talking about, even though it's a little confusing. So he's not, but that's what the court said. He said that the court said broadly he's a limited purpose. I need other words. And so you're trying to conflate these tests. So I understand why you're doing it, but no. To determine whether he's a limited purpose public figure, in so issue specific, Texas court applied 3 parts. The controversy issue must be public in the sense that people are discussing it and people other than the immediate participants are likely to feel impact. The plaintiff must have more than a trivial or tangential role, and the alleged defamation must be germane to the plaintiff's participation. To determine if Vic's role is controversy is more than controversial, a court examines whether the plaintiff had actually sought the controversy. Yeah. So we're trying to apply the standard for issue specific, limited purpose public figure. So that's what we're trying to do. We're trying to move the ball and say, oh, the issue is whether it's issue specific, limited purpose public figure. But that's not what the trial court said. This isn't issue specific. It's broader than that, but not so broad as to be general. There is no evidence Vic established himself as a limited purpose public figure by thrusting himself into the controversy. I agree with you. He's not limited purpose because of that. Yes, you are correct. You are correct, Ty. You're correct. Vic is not limited purpose because of him injecting himself into this controversy. Yes. Query whether or not I am either under either definition. But yeah, no, that's not the relevant standard. He's limited purpose. He's not limited purpose because he injected himself into this controversy. You're right. He's not limited purpose because of that. He's limited purpose because of the conventions and the autographs and the phonographs and the pounds discussions and the, yeah, okay. In fact, Vic testified he did not seek out this controversy, which must be assumed to be true. Sure. Before Vic ever published the tweets responding to him, he was the victim of numerous false claims. The controversy, Jenna, started with a tweet by, finally we put an ad in front of this person's name, at Helena, thank God. So we left off the at from earlier. So it was a person's name, it was their Twitter handle, and we just left off the at. How many grammatical and typing errors do I find in this brief? That's a good question. Some is the right number, apparently. It was misinterpreted as an accusation. Accusations on which Vic denied. Vic's IMDb page does not make him a public figure. Funimation fails to explain how the existence of the page establishes the resolution of the party's dispute involved a person, named Vic, whose promise is so high that will have a dispute on the impact of general purpose. Yeah, you're using the wrong standard. Using the wrong test for a limited purpose. I understand why you're doing it, but no. Someone said in the order Chup did not specify what type of public figure it is. That's okay. The Court of Appeals will do it for you. The Court of Appeals will say limited purpose. So, shame on the trial court for not doing it, but the Court of Appeals will be happy to do it for you. They're not going to punt it over that. Funimation fails to establish any particular degree of recognition, nor is such recognition demonstrated by the contents of the page. Funimation's evidence of website blogs is not sufficient to establish Vic as a public figure. Many of the blogs were published after the tweets. Funimation would have this court to believe the blogs are evidence of his status. However, the existence of the website, which were published after the tweet, is easily attributable to his status as an extensive media company. Yeah, okay, yeah, all that stuff, I agree with you. None of it matters. That's fine. While Vic did testify he has a fan club, there's no showing the fan club was of any significant prominence. Yes, yeah, I feel like here you are making a mistake that many lawyers do, and more to the point, a lot of people in the public do. So lawyers try to do this for effect. Members of the public tend to do this because they don't know better. But members of the public and lawyers, sometimes when they're trying to be a little misleading, what they'll say is like, this piece of evidence isn't dispositive, or it isn't enough by itself. Yes, that's probably true. It's not enough by itself, but that's not how we do law. Right? It's very rare that there's one piece of evidence that seals things completely. Normally, it's a combination of many things. So members of the public will sometimes say, oh, well, this piece of evidence isn't enough by itself. You're right. It's probably not enough by itself because it's unusual for it to be by itself. Most cases are not that clean. You know, occasionally it happens, but the vast majority of the time, no. Most of the things are not that clean. Usually it's a combination of stuff. Now, every once in a while, yeah. But members of the public will say, oh, this isn't by enough by itself. I'm like, yeah, it probably isn't. But you're mistaking its ultimate conclusive impact for its relevance. It's relevant. It makes it more likely than it did before. So for something to be relevant legally, by the way, in case you're curious about what makes something legally relevant, for something to be legally relevant, it has to make a fact that's in dispute more or less likely. Or a legal point that's in dispute more or less likely. That would be legally relevant. So when I say something is irrelevant, what I mean is it doesn't make a fact more or less likely, or it doesn't make a legal point more or less likely. That is what I mean by irrelevant. So like, yeah, it's relevant. And it's relevant because it makes it more likely that he's a public figure. The fact he has a fan club is relevant, and it's relevant in the direction of making it more likely than it would otherwise. That is a fact that tends to favor the conclusion. Does that mean that the conclusion is ultimately right? No, we need more. But he's trying to do this, like he's trying to attack one piece of evidence at a time. It's like, well, this isn't enough, this is enough. Yeah, I'm like, yeah, even if you prove they're all not enough individually, I don't care. I want to know about them in their collective weight. You know, so yeah, his fan club is not a significant prominence. Is that dispositive? No. Is it relevant? Hell yes. It makes it more likely that he's a public figure that he has a fan club than not. I don't think I have a fan club. If I do, I don't know about it. To the contrary, Vic testified that just as he's just starring as two women who like to show in which Vic Mignogna provide voice acting. I guess I did say we have the Uncivilians. So I have the Uncivilians militia. So yes, I guess I did start my own fan club, and it is very, very small. I've got like 10 people in my fan club. So all of you people who have hit the join button, if you too would like to be part of my fan club, so yes, I do have a fan club, and I started one. So yes, I have a fan club. If you'd like to be a member of the fan club, there should be a join button somewhere on your screen. And if you press that join button for 99 cents a month, you too can be an uncivilian, and you can be a member of my fan club. There's no evidence before the trial court to suggest a small group of individuals significant in terms of scale of individuals, activity, or public participation. Surely it would have any tendency to establish a public figure. I think it does have a little bit of a tendency to establish that. It has a little bit of a tendency to establish public figure. Not a lot, but some. The trial court ordered dismissing Vic's claim, stating the case was factually similar to this court's recent opinion. The facts in Lane do not support or not similar. Funimation supported its attempt to establish Vic as a public figure. In Lane, appellant. What is that one case, Khan, that really, really helps the Vic? Is at any point is he going to mention the Khan case, just out of pure curiosity? Because I don't remember that coming up a lot. It's like the only case that really helps you at all. It's Khan. Are we going to mention that? We're 17 pages into this and we haven't mentioned Khan. That's great. That's one of, if it's in here, we've buried the lead. That's great work. In this case, Lane, an opera voice professor, sued a student for defamation based on the social media. In the motion, the student offered the professional website, appellant's faculty page, the affidavit, and statements from the appellate definition. Ural Gray becomes a supporter. Thank you for becoming a supporter. You two are now part of the Uncivilian militia. So welcome. Thank you. There are two important differences between lay and Ferris in this case. First, in Lane, the appellee presented evidence showing how the resolution of the dispute would impact other people. If it was issue-specific limited purpose, which we're not talking about, that's a different kind of limited purpose. That's issue-specific limited purpose. So yes, limited purpose does come in two different varieties. It comes in an issue-specific limited purpose and a non-issue-specific limited purpose. So some limited purposes are more limited than others. Yeah, so we've got George Orwell Animal Farm over here. All limited purposes are equal, but some are more equal than others. What do you want from me, man? It's law, okay? Deal. In Lane, the substance of the appellee statement about appellant went to the fitness for performance as an opera instructor. Appellant in Lane was famous in the world of opera performance and instruction, and her fame was such the resolution of the accusations would impact her students' decision. Appellee offered evidence showing other students not only discussed the accusations against appellant, but also their decision to attend the university, as opposed to other universities, would be impacted by the resolution. $2 from Q Squared. My kid's bath time will catch more later, thanks, Kurt. You are very welcome. No problem. Additionally, appellant's own statements established her level of fame to the extent she had earned otherwise well-recognized and recognized even outside the opera community. For example, the court notes in Lane the appellant had been awarded, which included an Oscar, contributed to establishing appellant as a public figure. Sure. Although Vic lost work as a voice actor and convention invitee as a result of the tweets, there's no evidence in Vic's status in the general public as such that tweets about him would actually impact the general purpose's decision. Wow, I feel like you just said two things that are mutually contradictory in the same sentence. That's great. I feel like you just said two things that are completely contradictory in the exact same sentence. That's good work. Yeah. Although Vic lost work as a voice actor and convention invitee as a result of the tweets, but this doesn't have public impact though. Despite the fact that he lost invitations and voice work, this has no public impact. Okay. While Vic maintains the tweets caused him to lose work, that's the impact on Vic, not on the general public. Sure. Let's go with that. Yeah. So it was a problem in the opera singer case because people wouldn't attend the university, but it has no impact on the general public because people are just as likely to attend conventions as they always were. Presumably, the Vic fanboys are less likely to show up to conventions than they were. I mean, I can just take it as a given that it's probably true. You know, I don't need a whole lot of evidence for that proposition, I would think. Funimation argues incorrectly that it did not state or imply in its tweets that it engaged in sexual harassment. Concerning the substance of the tweets, statements can only be rationally inferred. Yeah, I'm with you on that grounds. I think the statements, I am with you on this one, Ty. I do think that the statements read in context do speak to making an accusation against Vic. So I think that's correct. So I think that the statements, the two tweets, do reasonably read as them making an accusation against Vic. So yes, you have that element of it, as far as I'm concerned as a judge. Yes, congratulations. You do have that. Yes, it was a statement about Vic when they said, we don't work with people who engage in sexual harassment, or whatever the exact verbiage is. It doesn't matter. But yes, you have it. The problem is you have lots of other problems because you do have limited public status, or maybe general status because you admitted to it. So yeah, you do have a statement that's about you, that is negative, that may or may not be factually a lie, but you are limited purpose. And also, even if you're not, okay, and even if you're not, I'd suggest you still lose. Because a statement, even if, see, this is where the other thing too, is like, even if Vic is not a limited purpose public figure, Vic still loses. Because you can't even get to negligence. And that's the problem for Vic's side. So like, that's even a problem too. Like, it's a better case, make no doubt. He was much better off on the tortious interference claims than he ever was on the defamation claims. So the defamation claims were always really dicey for reasons I'm going to explain in a minute. The tortious interference claims were a lot better because he should have been able to show and could have been able to show direct conversations that directly tortiously interfered. So the tortious interference claims were a lot better, a lot more promising. Here's the problem. So that was, but he didn't show that. He didn't raise any of that evidence. It wasn't presented. And so he screwed the pooch on presenting the evidence on the tortious interference stuff. Here's why the defamation stuff was probably a loser from square one. Yes, the statements on Twitter were probably about Vic. Here's my legal conclusions if you ask me as a lawyer or ask me as a judge. Yes, the statements by Funimation were about Vic. They were about and concerning Vic. Yes, the statements concerned Vic. And yes, they made accusations of Vic and sexual assault. And yes, they could be understood that way. So here's your first of all, he's a public figure, so you have to show malice. But even if he's not a public figure, here's your next problem. Even if he's not a public figure, you have to show they're at least negligent. So not only do the statements have to be false, they have to be at least negligently made. At least negligently made. So if you're in public figure status, you have to show actual malice. If you're not public figure status, however, you have to show negligence. That's your baseline minimum for a tort, is negligence. Negligence. And so the problem there is that Funimation probably clears that hurdle. They clear that hurdle because they did do a investigation before they released the tweets. And it probably was sufficient to not be negligent. Now, they probably could have done more, but it probably was enough to clear the negligence hurdle. They probably did enough to make the statements on reasonable reliance on what their investigation untold, and probably made enough for the statements to not be negligent. So even if the states are ultimately false, you're going to lose on the mental state element. You're going to lose on the negligence. Because I think Funimation did enough to pass negligence. So your defamation claim was always a loser. Because yes, they were about you. Yes, they made accusations. Yes, they were even per se, because they're per se defamatory. So you got that going for you. You don't even have to show damages. Yes, they're about you. Yes, they're a particularly damaging matter, so you don't have to show damages. Yes, even maybe they're false. Yes, even they're false. But they're not made with negligence. So Funimation's in the clear, man. Funimation did enough to pass the negligence threshold. So you're having a bad time when it comes to the defamation claims, man. You're much better off on the tortious interference claims, and you really screwed that one. Funimation's tweet said it's an update on the Vic Mignogna. Yeah, some people were asking me about tortious interference. I should have explained that better because I kind of blew past it. But tortious interference is interference, which is tortious, and tort is just to say a civil wrong. So all civil wrongs that are not based on contract are torts. So assault, battery, false imprisonment, adverse possession, anything I can do to you civilly that's not contract is tort. So tortious interference means basically what it means is I'm a third party and I'm injecting myself into a contract between two other people. So, for example, going and whispering lies to one of the other members of the contract so as to induce them to breach your contract. That would be an example of tortious interference. You know, I did something as a third party to inject myself to one of the other parties in order to get them to break the contract in a way that is not fair. You know, so spreading lies and causing them to break your contract, that would be tortious interference. So those claims were a lot better. Unfortunately, Vic never showed them. So that was good. Funimation's tweet stated its decision to exclude Vic was following an investigation, which it was. The only rational inference is that Funimation's investigation and determined them to be credible. Yeah. The fact is, Funimation conceded that its exclusion from Vic from proceedings resulted in the investigation. The fact is, The fact is, Funimation conceded that its exclusion of Vic from future Funimation proceedings resulted from the investigation. Yeah, I think you're there. I think those tweets can be read about Vic, yes. Funimation's first tweet could be reasonably read as confirmation in second. Yes, I agree. Funimation's second tweet confirms this. I agree. Funimation concedes this interpretation by stating the second tweet was in response to and continued back and forth. Sure. However, even if true, Funimation failed to make it clear the second tweet was not a reference to Vic. It's about Vic. I'm there. A reader could easily infer the harassing behavior was uncovering. Yes, I agree. In short, Funimation's second tweet confirms the meaning of the first and accuses it. The rational inference is all that stuff. Yeah, I'm with you. I'm with you, Ty, on that one. Yes, I think Funimation is wrong. I think you're right. I think those two tweets can be read. We have tweet number 1 that says we're not going to work with Vic anymore. We have tweet number 2 that says we, in general, don't work with people who have been accused of sexual harassment. So yes, you could read one in light of the other. A reasonable person would read light of one of the other. In fact, I think it was a direct response. I think it was a direct response tweet. So not only were they two tweets that were contemporaneous, I think one was a direct response to the other. Not that it legally matters or necessary, but yeah, I think they were direct responses. So yes, I agree with you, Ty. The two statements were about Vic. They did present him as a sexual accuser and all the rest of it. Unfortunately, you've got all kinds of problems all over the place. But you win as to that much as far as I'm concerned. So hooray. Vic reinforces his position the trial court erred in refusing to consider his Second Amendment. Okay, finally we're getting into the Second Amendment. Maybe we'll make some arguments. That'll be nice. However, sufficient evidence was presented to support each of the claims because Funimation's motion to dismiss included attached exhibits that established the elements for each of Vic's causes of action. Yes, assuming you were allowed to do that, which is a major point of contention. Funimation misstates the scope of the evidence before it by failing to acknowledge the trial court considered the exhibits attached to the motion itself. They did for some limited purposes, yes. Trial court also considered evidence offered by Rial, Toy, and Marchi in connection. Yes, but their stuff was properly considered. So yes, the trial court definitely considered the stuff offered by Rial, Toy, and Marchi because they followed the rules. Ty, they followed the rules. That's why their stuff was considered, because it was properly presented to the court, like that you do when you want to present evidence. So of course the court considered it. What are you talking about? They would have considered your evidence too had you presented it in, in a lawful way, which I don't think you did. And neither does the trial court, as far as we can tell. So, Such evidence also clearly and specifically establishes each of the causes of action. No, it doesn't. The trial court held a single hearing for all the motions to be heard together. Yes, they did hear a single hearing. We live reacted to that hearing. We read the transcript. And we facepalmed with increasing frustration as the trial court became increasingly frustrated at Ty's inability to answer basic questions like, what contracts are you talking about? What contracts were a problem? Would you like to tell me about the contracts? What contracts? Any time would be fine. Yeah, they held one hearing. They decided one hearing was enough. Do I blame the trial court? I do not. I also feel like one hearing is enough. I feel like I got the gist. I'm ready to roll, man. I am ready to roll. The record does not reflect that any evidence was limited to any particular purpose. Close enough. Due to Funimation's failure to prove that he's a public figure or a limited purpose, he's a private figure. No, he's not. Therefore, to defeat Funimation, Vic was only required to show clear and convincing evidence that he acted with negligence. See what I just said? Remember about the negligence thing? I wasn't making that up, Vic, people. I don't make shit up. When I say, yes, you have to prove negligence, I'm not making it up. So your hero Ty himself says, yes, you have to prove negligence. Because that is the baseline minimum standard. So yes, I don't make shit up. When I say, yeah, even if he wasn't a public figure, you still have to say negligence. You know who agrees with me? Ty Beard does. Don't at me. Therefore, to defeat Funimation's TCPA motion, Vic was only required to show clear and specific evidence that they acted with negligence in publishing the tweets, which, Texas courts have defined negligence and defamation as failure to investigate the truth or falsity before publication and failure to act as a reasonably prudent person. I think we kind of got there, but all right. Sufficient evidence was admitted by the trial court to make that showing. Wow. You think there was sufficient evidence to show a failure to investigate or failure to act responsibly? I'm going to press X to doubt on that one, personally. Considering the only evidence offered in the motion to dismiss, the trial court had Vic's tweet, which he specifically denies the allegations of sexual harassment, were the basis of the tweet. That doesn't mean that Funimation acted with negligence. That's not what, just because you disagree with them doesn't mean that they acted with negligence. This is not true. Does that mean if I say, yes, it is true, I'm acting negligently? No. Not definitionally, no. In order to be negligent, I have to be negligent. I have to not show the proper duty of care. So yes, you saying one thing and me saying another means one of us is wrong, but it doesn't mean that either of us is necessarily acting with negligence. You need a little bit more. The affidavit of Tammy Denbo details the scope of Funimation's investigation and the accusations. Funimation's investigation merely included a review of the unsupported internet posts, many of which were made anonymously and often just repeating allegations, discussions with Rial, who injected herself in discussions with 2 anonymous fans, and a single phone call with Vic. I'm not sure if it was limited to that, and even if it was, I'm not sure that doesn't make negligence. Negligence, it's like, that might be enough. You know, Rial was one of the principals. Wasn't it Rial who said that Vic like sniffed her hair or whatever? So Monica is like one of the principals. She's a direct eyewitness to this purported hair sniffing. That was Monica, right? With the hair sniffing thing. So if we talked to Monica and we talked to you, it's probably enough for us not to be negligent. And we also consider some other stuff. We talked to the principals involved. It's probably enough. It was Marchie, not Monica. Okay. I apologize. So yes, we didn't. So they're saying we didn't actually talk to Marchie. We didn't actually talk to Marchie as part of this investigation. Really? They didn't talk to Marchie? That seems odd. Oh, Rial was the jelly bean? That's so stupid. Like, even if that's true, the idea that sexual harassment is just the lamest thing I ever heard in my life. First of all, the hair sniffing thing, okay, maybe. I mean, that's more debatable, but like, even if every word of the jelly bean incident is true, that's sexual harassment, really? I have a jelly bean that says Monica on it, and I eat it and say, look, I ate Monica. That's sexual harassment? 10 years later? Okay. That was so lame, man. Funimation does not include the content of the conversation, but concludes the allegations are credible. Since Funimation, yeah, all right. I'm just going to get a jelly bean and just write the chat on it. Just pretend I'm holding. I am now holding a jelly bean in my hand, and this jelly bean says the chat. I have ate the chat. Ooh, what? Apparently this is a no-go or something. I don't understand. It's a very bad dad joke is what it is. Since Funimation reviewed the tweets accusing Vic of sexual assault and sexual harassment and permitted Rial to inject herself in the investigation, Funimation knew that Rial claimed there were hundreds of victims and would be facing criminal charges. Well, that might be something. Tactical, you're going to have to talk to your husband on that one. Funimation's silence on the absence of this witness and criminal charges is defamation. More importantly, such failure to explain the glaring evidence, lack of criminal charges, demonstration of fact, did not reasonably prudent person. Even if Vic is considered a public figure, sufficient evidence was before the trial court to support a finding that Funimation publishes tweets with actual malice. Yeah. Actual malice is showing where there's reckless disregard of the truth. Sure. Yeah, the way I like to say this is when we talk about actual malice, the malice is to the truth as such, not to the person. The malice is to the truth, not to the person. That way it's a lot less confusing. Funimation provided no evidence of how to decide these cases, and even in Turner, where an appellee was mistaken in its belief, the court records support the contention the appellant was involved in an insurance scam. The appellee provides sufficient evidence. The appellee could argue good faith. Which I think, Funimation's probably there. Tammy Denbo's affidavit, complete with... Also, weren't there affidavits from other people? There were other affidavits. So, from Funimation, who incidentally presented them in the proper way. So, I think Funimation probably gets past negligence. So, on a motion for summary judgment, probably still ruling for Funimation on even assuming Vic's not a public figure, because I'm probably sure they can get to negligence. They can meet their negligence threshold. So yeah, Funimation probably in the clear on the defamation. You go, Funimation. You seem like you're in the clear. Funimation is not entitled to presumption it had any basis for truthfulness. Yes, it is. It's absolutely entitled to this. It did interviews and discussions and all that stuff that you just talked about. It had basis. What are you talking about? The evidence does show Funimation had some motivation to respond to Rial, Toy, and Marchie's tweets, which repeatedly and vocally attacked Vic and called on Funimation to investigate. By publishing the false tweets, Funimation published its tweets without regardlessness of the truthfulness. Worse, Funimation amplified Toy, Rial, and Marchie's false accusations to a much broader audience due to the Funimation's status in the industry. It also claimed to investigate and found evidence to support the investigation, which they did, and they did. You know, whether or not it's enough to pass the negligence threshold, I suppose we could have a discussion about, but probably, yeah. Probably enough to pass negligence. Negligence is kind of hard. I mean, you know, negligence is usually pretty easy to make that thing, but I think we're there. I think we passed. I think Funimation's in the clear. Funimation's evidence in its motion to dismiss shows Vic was damaged by Funimation's tweets. Yes, also it was per se, so we didn't even need to show damage, but you know, whatever. Funimation also argues Vic failed to provide evidence of actual damages, which is per se because we don't have to. Although Vic maintains he's not required to show damages because they constitute defamation per se, they do. The trial court was presented with evidence of actual damages, specifically offered evidence that conventions were canceled. Not that you presented them very well because the court kept asking you, what contracts? I remember the hearing. I remember the court keep asking, what contracts? Which ones? What are you talking about? What damages? And you're like, well, you know, there were a lot of contracts. There were so many contracts, Your Honor. Which ones? Tell me about them. So many. And that was a frustrating hearing to read and live react to. That was very frustrating, man. I was feeling the court's sanity slip with every page. It was a thing to behold. Funimation fails to acknowledge this court's presented evidence and accusations of sexual misconduct or defamation, which damages are presumed. Is it too late for Tiebeard to produce the contracts? Hell yes. Hell yes, it's too late. Yeah, no, we are way past let's present evidence stage. If we want to talk about the potential future malpractice suit against Vic's lawyer, well, we can talk about that. Well, we'll cover that. That'll be a good one. Mignogna versus Beard. Perhaps coming to a courtroom near you. Lord. Funimation begins to acknowledge its own evidence in arguing that Vic failed to show evidence of tortious interference with existing and prospective business relationships. Funimation's own exhibits show Vic lost contracts with prospective business relationships due to false tweets. Vic Mignogna's claim for vicarious liability in connection with the tweets is supported by evidence of control exercised by Funimation as the decision to publish certain tweets. Yes, but under Texas law, they have to be employer-employee, not contractors. And they were contractors. So their control does not seem to be sufficient as a matter of Texas law. So, no, it doesn't matter. How do you show a verbal contract? Well, ideally, getting them to admit to it would be nice. But any writing at all, so like a confirmation email, so nice to talk to you, you know, thanks for agreeing, something in writing that's contemporaneous, someone who will admit to it, actions taken on the contract. So, you know, if you can show actions that were taken that would be pursuant to the contract, then you can argue that the contract exists, right? So, like, we don't have a contract, but I can say, well, I have evidence you did A, B, C, D, E, and we have a contract, and that's part of the contract, so that might help. But anything in writing would be helpful. Party admission would be helpful. Yeah. Excuse me. Funimation's analysis fails to give proper consideration to the specific facts and inferences supported by the communications. In fact, the specific statements made by Rial in her email are sufficient to support a finding that Funimation exerted control over Rial's tweets. It doesn't appear to be the right standard under Texas law. Not that I'm an expert in this area, but it appears that under Texas law, you have to be an employer or employee, not a contractor. So it appears there's no vicarious liability if you are not a employer within the meaning of employment law. Rial's email to Lisa Gibson not only states that Rial doesn't know what to say when people ask about the investigation, she specifically adds, I don't know what I can say, which implies Funimation has some authority. No, that really doesn't necessarily imply that. Just because someone's like, I don't know what I can say, doesn't mean that anyone in particular has authority, or that she doesn't want to undermine the people she's writing tweets for. She's like, I'm not sure. So she's not sure what she can do. You're reading a lot into that, man. No. Funimation may be willing to make a statement until Dragon Ball Super Broly has finished its run, or may not want to make a statement. It supports a rational inference that controlled tweets. Funimation's argument that the trial court properly dismissed Vic's claim for civil conspiracy is predicated on the assumption that the underlying claims were properly dismissed. Yes. Yes, and they were. As detailed above, the trial court was presented with sufficient evidence to allow Vic to defeat Funimation's TCPA motion as to each of Vic's underlying claims. Vic's claims were improperly dismissed, which presented with sufficient evidence. As shown above, Rial's email to Lisa Gibson asked for instructions. Okay. Additionally, the trial court was presented with evidence supporting rational inference that tweets were actually published. The concerted efforts of Rial and Funimation was enough to support a rational inference that had a common goal and meeting in the minds. Lame. Funimation's argument supporting its awards of attorney's fees is predicated on a conclusion the trial court properly dismissed. Because the trial court dismissed each of the actions were in error, the trial court's attorney's fees must be vacated. Blah, 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 whatever, some other things I don't care about. Okay, that was super fun. So that's the end of our Sur Reply. This is the end of our Sur Reply from Vic Mignogna, courtesy of Ty Beard. So Vic has filed a Sur Reply, which is a neat trick, because I didn't think that was possible. Both because it's impossible and because you didn't have permission. So that's a neat trick. And also, Vic is a general purpose public figure because we don't know how to proofread. And also, we are quoting tweets with ellipses and we're not writing sick and other stuff. Oh, did I explain why the font is blue? Just to make it easier to read. So I think it makes it a little bit easier on the eyes. So I've changed. So I've in Adobe, or yeah, in my PDF reader, I've made the background a little bit off-white, and I made the font blue, because I just think it's a little bit easier to read than black on white. So I thought it made it nice. So it's blue because I decided to make it blue. It's not really any more complicated than that. So, I thought it was, because, when you have a bright white background, it's so glaring. So I was like, I'll make the font a little bit different. So I'll make it, off-white, and make it a little bit less glaring. I'll make the font kind of a blue instead of black. I think it looks nice. That's why it looks that way. Yeah. I changed it. I changed it in my PDF reader. So yes, lest anyone think that I'm making accusations against Ty or something. No, he wrote it on black ink on white paper. I changed it to the colors that you see because I think it makes it a little bit easier to read. Yeah, so the collective hive mind of the I stand with Vic people is better than Ty. So my prediction is Vic is going to lose. I'm going to give about 90. Geez, I'm trying to figure out where to put what comes after the 9 in this equation. Let's just say 90. Let's just say flat 90. We'll give it a 90% chance for Vic to lose and Funimation et al. To win, because this is meandering. The central issue is what is the amended petition. If it's not the second amended, then we're just done, and we didn't spend any time really rebutting that at all. And I also point out to I've pointed out to the Vic people that at this point I have read more documentation on this case than the Court of Appeals will ever read. Their clerks probably aren't going to read this much. They might, but I've done a pretty deep dive on this case. I've read way more than the Court of Appeals is going to read. The Court of Appeals is going to have a half-hour thing, where they're going to ask for things, and they're going to write an opinion, and they're going to pwn Ty and Vic hard. And the only question is how much money, because I think the trial court reduced it down. I think originally it was $500,000 in damages. I think they reduced it down. I want to say it's $100,000 in damages now, but don't quote me on that. So in terms of the monetary amount that Vic has to pay for legal fees. So I think it got reduced from $500,000 to like $100,000. But yeah, and it's a reasonable number for the amount of hours that were poured into this and stuff, and that it's a reasonable number. So I think that's going to be upheld. So I figure 90%, 91%. Let's go 91% chance that Vic is going to lose, and Ty Beer doesn't know what he's talking about, and then I guess Vic will have to decide whether or not he wants to sue Ty. So for malpractice or not. I'm not admitted to Texas yet, so I just want to let you know I'm not available for this one. So you'll have to find some other lawyer. Also, I don't know that I'd want my first case to be a malpractice case against another lawyer. In Texas, I don't want necessarily start off that way. What is the SIR reply? You missed that whole discussion from earlier, but we'll do it again for you. Yeah, SIR reply is just what you do after it's fourth in a sequence. So in normal law world, a SIR reply is just fourth in a sequence. So normally it is the initial filing, the response, the reply, and the SIR reply with the alternating parties, right? So the first party files the initial filing, then the other party files the response, then the first party files the reply, then the other party, if they can, files a SIR reply. So it's an additional reply. Here's the thing. The Texas Code of Appellate Procedure doesn't recognize SIR reply. It doesn't use the word SIR anywhere in its rules. It doesn't recognize it. And also Vic literally can't file it at all because he's the wrong party. So we call it a SIR reply when it's a reply. So that was super, super fun. Yeah, a SIR reply would be a reply to this, which you have to ask permission for. If I'm the other side, I have to decide if I want to file a motion to strike or not. If I'm the other side, it's like, do I file a motion to strike on the basis that there's no motion for a SIR reply? I don't know. I have to think about it. I'm not sure what the legally correct move is. Maybe I just let him be embarrassed. That'd be fun, and bring it up at oral argument. Yeah, that'd be more fun. Yeah. Oh, incidentally, yeah. As soon as a date for this is established, I'm absolutely going to this hearing. I don't think a date has been established for this hearing. The Court of Appeals website still is not like updated since like April. So I'm not. So someone on Reddit got this somehow. But yeah, as far as I know, there's no date for the oral argument. But yeah, so it's in Fort Worth, I think. That's like a 2-hour drive from Austin. I'm absolutely going to this oral response or this oral reply, and so I get to meet the Vic people in person. That'll be fun. So yeah, I'll get to wear my cowboy hat because it should be in the mail by then. So, or I should be able to get it by then. So I'm pretty excited for that. So, good stuff. Good stuff. Yeah. Yeah. He conceded. I'm not filing a motion to strike. That's right. Yeah. Yeah. So I forgot what the damages were. I forget if they reduced it to 100,000 or something, but his lawyer is not very good. So I understand. I think Rakita might have covered this already. If not, I look forward to Rakita covering this. Because, man, I don't know, man. Also, if you're out there, Rakita, I'm still interested in doing a thing with you. So, you know where to find me. So, anyways. Oh, I think everyone's coming along for the ride. I mean, I just normally speak of Funimation versus Vic in short, but I think everyone's coming along for the ride. So I don't see a court splitting on like some of the parties going one way and the other going another way. So I think Monica, Real, Toy, and Funimation are, they're all winning or they're all losing. I don't see that. I don't see it getting split. Yeah. So we'll see. If you liked this stream, for these 80 of you who are currently here, if you'd be so kind as to give the stream a like. Also, if anyone in my Discord would like to post the link for my Discord, my moderators, now would be a fantastic time. I am trying to start a Discord on a trial basis. So you can come to my Discord and you can yell at me nicely. And you can suggest story ideas and whatever. We're giving it a try. I'm not promising that it will stay around, but we're giving it a go. With the filing this bad, can't Funny and O go for fees? They're already doing that. They're already going for fees, and yeah, they'll get their fees. They're getting their fees. So we'll do all that, and so I appreciate all of you who are here, and hope you're well. I might be on with Viva later today, so that might be fun. Until later, my friends. Peace. Goodbye.